welcome to Monday with Business Immigration at IMD Corporate. I'm Alicja Bielawska, a trainee solicitor specializing in corporate, commercial, employment, and immigration, and I'm joined by my co-host Jarmila Entezari, a senior associate with over 18 years of experience in business immigration matters.
Hello, everyone. Thank you for joining us for our second episode. Today, we will be exploring world of employment law and immigration, focusing especially on how the skilled worker visa impacts employers and employees.
Exactly. It's a complex but essential topic for businesses that employ international workers or are thinking about sponsoring employees. We'll cover employment contracts, HR management compliance, and much more. Plus, we got some real life examples and tips to share along the way. So, whether you are an HR professional, business owner, or just curious about how immigration law interacts with employment, stick around. It's going to be a packed episode. Okay, Jarmila, let's start with basics. What is the skilled worker visa and why should employers care?
The skilled worker visa allows UK businesses to sponsor skilled workers from abroad. To qualify the role as well as the worker needs to meet certain criteria, like for the role being on the eligible occupation list, meeting minimum salary thresholds, and the worker having relevant qualifications or experience to carry out the particular role. Also, the employee should be able to prove knowledge of English language at least B1 level and be able to support themselves when they arrive in the UK. So they usually need to have at least £1,270 available unless the sponsor, the employer, is able to certify the maintenance, which means that the sponsor will agree to maintain and accommodate the migrant worker and their dependents up to the end of the first month of their visa.
So, this is for an employee. The employer needs a sponsorship license. And by the way, we will definitely record a separate episode about skilled worker visa.
Definitely. And yes, that's correct. And as we said in the previous episode, in our first podcast, holding a sponsor license comes with significant responsibilities, from maintaining records to ensuring compliance with the Home Office rules. And it is not only about immigration law, but employment law as well.
Yeah, because the visa holder will become an employee, and the employer, so the sponsor, has to adhere not only to immigration rules for the reason of it being a sponsor license holder, but also to employment law. For example, an employer cannot discriminate the worker because of their race or nationality. This is so-called protected characteristics, or immigration status, as this can be seen as indirect discrimination depending on the circumstances, and the employer risks facing a claim and possible compensation. This is, however, just an example of how the employment law can play a role. In fact, the employer will have to comply with employment law from day one and treat the visa holder employee as any other employee. So, for example, provide them with so-called written statement of employment particulars, which includes basic information about the employment, such as employer's name, employee's job title or job description, hours and days of work, salary, holiday entitlement, and so on and so forth. The only difference between sponsored overseas worker and other employees is that the sponsored employee will have additional obligation to comply with immigration requirements, and the employer will have additional duties and obligations to the Home Office.
And when employing a skilled worker, businesses need to ensure that employment contract complies with both UK employment law as well as immigration requirements.
That's correct. And by the way of example, um, the job title and description in a contract must match what's on the certificate of sponsorship. Otherwise, this can lead to compliance issues. In terms of salary, the contract should state the amount which must meet or exceed the skilled worker visa threshold for a specific role. If the role requires travel or work at multiple locations, specify this in the contract. A change in location not included in the certificate of sponsorship must be reported to the Home Office. A termination clause should be tailored to include grounds for ending employment if the employee loses their visa or breaches immigration conditions.
Oh, Alicia, it sounds like the tailoring contracts requires a lot of attention to detail.
Definitely, because you need to keep in mind both employment and immigration rules. Some of the employers, for example, one of our clients recently, decided to pay visa application costs for the future employee. And obviously, the employer wants to reduce a risk of losing money if employee decides to terminate the employment early or not show up at work at all. Um, this can be achieved by so-called clawback clause, which reads, for example, that if an employee resign within, let's say, 24 months, they agreed to pay a specific amount or percentage of visa-related fees to their employer.
Yeah, so a well-drafted contract not only protects the business, but also ensures that the employee feels secure and supported in their role.
Of course, the contract is one thing, and well, enforcement is second, but it's better to be secured that way than not secured at all.
Sure.
Now let's turn to HR policies and compliance. For businesses employing skilled workers, what does good practice look like?
Good practice starts with robust HR policies that address the unique needs of skilled worker visa holders and ensure compliance with the Home Office requirements. The compliance will be checked by the Home Office during the audit visits, which can be either announced or unannounced.
Mm.
Um, Before employment begins, employer must verify the employee's right to work in the UK and regularly review and update records before, especially before visa expiry dates. Employers must maintain comprehensive records for all skilled worker employees, including copies of the passports and visa or biometric residence permits for those who still have it, the signed employment contract, attendance records to confirm the employee is actively working in the assigned role, and some personal details such as home address.
And if an audit happens, those records are what the Home Office will check.
Exactly. So during an audit, the Home Office will assess whether the employer continues meeting their sponsor duties. Poor record keeping is one of the main reasons the sponsor license gets downgraded, or some sponsors even lose their sponsor license. And though the sponsor management system, through that sponsorship management system, sponsors must report changes to the employee's role, such as, I don't know, promotions, where the pay and duties change, or location changes. If the employee stops working for the sponsor, that must be definitely reported straight away or within 10 working days. Absences of more than 10 consecutive working days without the sponsor's authorization, and any breaches of visa conditions like more than permitted hours in a secondary working job.
I would also add training for HR teams.
Oh, of course, that's very important.
Yeah, you should really train your HR staff on immigration compliance, including how to use the SMS and conduct right to work checks. Non-compliance can lead to severe penalties, such as fines of up to £60,000 per illegal worker and criminal persecution. Revocation of sponsor license, make it impossible to sponsor skilled workers in the future. reputational damage, which can affect future recruitment and business opportunities. And in the best case scenario, the Home Office will downgrade the sponsor's rating, which will mean receiving an action plan for which there is a fee, and subsequently taking action to rectify any errors, as well as improving compliance within the business. The business will be flagged up in the Home Office records for quite some time.
So, a simple example would be a company sponsoring an IT specialist under the skilled worker visa route, and the employee moves to a new office location, but the employer just simply forgets to update the sponsorship management system. That's a non-compliance.
Yeah, if the Home Office conducts an audit, they could find that the employer didn't report the location change. Even if it seems minor, it's a breach of sponsor duties and could result in penalties or loss of the license.
Yeah, so that's a good reminder of why compliance process needs to be solid.
That's all for today's episode. We hope this was a helpful introduction to employment aspects of the skilled worker visa.
And if you are an employer and have questions about compliance or sponsorship, feel free to reach out to us.
And don't forget to subscribe to our newsletter for more insights on law and business. See you next time.